This courtroom showdown is about to get intense. Today, we're stepping inside the high-stakes hearing of Barrage Scott, a man whose criminal history is long, whose emotions are raw, and whose courtroom plea might just be his last shot at freedom. But hold on, this isn't just another bond hearing. This is a case where mental health, second chances, and serious allegations collide. His attorney paints a picture of a reformed man, medicated, supported by family, and begging for a chance at outpatient rehab. But the prosecution isn't convinced, and neither is the judge. With a history of reoffending and failing to follow through, the stakes couldn't be higher. Will the court show mercy, or are the judge's hands tied by the past? Watch closely, because what unfolds here is a brutal clash between hope and hard reality. And trust me, you'll want to see what happens when Mr. Scott tries to take control of the courtroom. Let's dive in.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from the situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released.
This is the turning point. You can hear the defense making a desperate appeal for compassion, laying out Scott's improved mental health, his commitment to medication, his support system, even his willingness to wear a tether. But then, the prosecutor steps in like a cold gust of realism. Their voice cuts through the sympathy, calling out Scott's past behaviors, manipulation during evaluations, and the very real danger he still poses. This is where emotion meets hard facts. And when the judge delivers the bond denial, you can feel the weight of experience behind it. She's not just making a ruling, she's recalling a pattern. Scott's last release ended in another arrest. In just 7 days. So here's the real question for you watching. Is the system failing people like Scott, or is Scott failing the system? Drop your thoughts in the comments. Should mental health outweigh criminal history in a bond decision?
I'm going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters, and typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since this
You understand what he's saying to you?
violent case.
So, hold on, do you understand what he said to you?
So
He said that he let you out. This happened a week
I
later.
know, but he keeps saying the same thing.
Okay.
The same thing that he said.
Okay. I believe Mr. Scott wants to address you directly, Your Honor, if you don't.
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here. My family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests, and the first one he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What would it happen if you keep me in here and then she just something happens? No, listen.
Mr. Scott, no, you listen. You listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
What do you mean?
Listen,
can you just let me
motion for
judge?
bond reduction denied, bond will continue.
Thank you, Judge.
But you ain't let me speak, though. You ain't even let me speak.
Thank you, Judge.
And there it is, the final gavel drop in a hearing packed with emotion, contradiction, and consequences. Barrage Scott poured his heart out, pleading for structure, for help, for a chance to rebuild. But the judge had heard it all before. Her ruling wasn't just a legal formality, it was a reflection of experience, of broken promises, of chances already given and wasted. From the competency evaluation to the impassioned plea, this case reveals the razor-thin line judges walk between compassion and caution. It's a stark reminder that in the courtroom, good intentions are never enough without follow-through. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.